I am John Nuechterlein. I'm the General Counsel of the FTC. I will begin with my usual disclaimer, which is that I'm not here speaking for the FTC or any commissioner. That will probably end up being a superfluous disclaimer because I intend to say very little of substance, instead leaving that job to our esteemed panelists here. All the panelists today focus to some extent on how best to, in a word, to shoehorn 21st century technologies into 20th century legal constructs. And until Congress acts, that's how telecom lawyers and many people around the room will put their kids through college. But it does actually present, yes, it does actually present a variety of the fact that the laws that we are applying to the internet age were enacted 15, 20, 25, 30 years ago makes a lot of these statutory classification debates almost scholastic in their ability to glaze the mind. We've been focusing a lot in this industry on how to classify broadband internet access services, and that was to some extent the focus of the first two panels. This last panel will address a different set of classification issues that are directed mainly to video services, ranging from the subscription video services offered by ISPs over managed IP platforms to over-the-top video services offered by the likes of Netflix and Hulu. The classification issues raised by these 21st century video services will take us beyond the definitions of information service and telecom service that we have come to know so well, and into the even more obscure worlds of Title VI of the Communications Act and Section 111 of the Copyright Act. How we parse the definitions contained in those provisions will significantly influence the future of television in America. And we are joined here by three experts in the area who will help us understand what some of the issues are and what some possible resolutions may be. Their bios are in your packet, so I'm not going to go through them. I'm going to introduce them only in the order in which they're speaking. Jim Speta will go first, and we'll talk specifically about specialized video services. Oh, yes, and I should add that what the fourth panelist, Markham Erickson, who would have been here, has been detained by family events, and so therefore can't join us. Thank you.
Okay, let's see. There I am. Okay, so I want to thank Christopher and Penn for having me down. Thank John for moderating and have the introduction. I want to say a few words mainly about the interaction between what I see as first, second, and third generation division of pipes, or tubes if you prefer, on single platforms when you're trying to suss out what your net neutrality concept should be for whatever portion of the network on which you want to have a net neutrality portion or not, as the case may be, and talk about some of the interaction effects for that. Old world, different services lived on different networks. If I say anything more than that, you'll drum me out of the room, because that's been said in this room more times than we all need to hear. Now we have one pipe, different services, maybe sometimes different technologies on that single network, but trending towards all the same technology on that single network, even though they're providing different services. And the news about what the FCC may or may not be working on in terms of redefinition behind the scenes will be more for my co-panelists, but obviously that is the transition from different parts of the network using different technologies for different services to the same network using the same technology for different services, and there's a wholly gratuitous picture of Jon Stewart and Tenth Stevens. So I wanted to look at this from the end of the network. Sort of artificially, I've created this concept about you've got this single amount of bandwidth in your multi-purpose network. What are you doing with it? And these dates are arbitrary, but in the late 90s and early 2000s, you're taking your network and you're dividing it between cable services defined as we define them in Title VI of the Communications Act, and we do some re-engineering and we add internet to that. Right? So we've got two services. They are at this time using pretty different technologies and providing different services and have entirely different business models, but they're being provided over the same network. And so later on, we move to, I don't know, the early 2000s, and we get this problem of what to do with the regulatory treatment of these two parts of the same network. And we say we're going to have net neutrality, at least as a policy statement matter. We're going to be the FCC and move in that direction for that part of the network, and we're not for the cable services network, and we're not for a lot of reasons which are embedded in the Act itself and also in the explicit history of the 84 and 92 Act, when Congress very intentionally considered the question, to what degree do we want to allow vertical integration in cable services, and said, we want to allow at least some of it, because it's not all bad and it's not all good, so we're going to create these regulatory schemes about which much can be said, but nevertheless, the bottom line judgment both of Congress in considering it as a policy matter and embedded in the Act itself are a set of rules that say vertical integration to a certain degree is okay, and we're going to have a set of implementations, and we can get into details about program access rules and must carry, et cetera, if we want to, but you know what those implementations look like, and my friends are going to talk a little bit more about that. So if you're a cable company and you've got this scheme, as some of us realized, principally an article by Hazlitt, but a bunch of us were writing in this area at the time. If you're a cable company and you see this and you're worried about your video platform having competition from emerging video on the internet, what do? Well, you just shrink your internet capacity to decrease the ability of a high-quality video service to emerge on the internet platform. Now, I'm not saying folks did that, but that would be the logical business response to it. And in the mid-2000s and up until the National Broadband Report, et cetera, the government starts to realize, okay, we understand that that can be done, and we want there to be video on the internet, so we're going to deploy a response to that, and we're going to deploy a response which says the law will force you to keep at least a certain portion of your network available for internet services, right? Whether it's 4 megabits or 12 megabits or which line. There have been a couple of different lines drawn in different proceedings. So that's 2010. 2010, we get some more formality to the fact that we want net neutrality on the internet pipe, but we still can't have it over cable services. So that's first generation. That's second generation. Now what are we in third generation? As John said, I'm going to talk a little bit about specialized services. And so if you're the cable company and you're going to respond to some of this, you just divide it into a third type of service being offered over the same network that are called specialized services or sometimes managed services. You put your video on demand there, you put your home monitoring system, you put your health services, you put all kinds of services over there. You don't have to count them. You can treat them differently. The net neutrality rules may or may not apply. I needed an arrow here, and the best thing that I could come up with for what we've thought about this is sorta. Right? And so the FCC in the merger conditions, the NBC-Comcast merger conditions, and in the open internet orders says, we get this, we understand that this can happen, and we're going to pay attention to it. But it's not net neutrality, whatever, or open internet, or whatever version of that you prefer, right? And so you get, and you can see in the market, and we all have seen in the market, very specific instances of this. We'll put video on demand here and not count it against your broadband or your bandwidth cap. That was extant for a little while. But we know, because the white papers are being written by the consultants, that the carriers who are providing you broadband access want to get into all these emergent markets like health monitoring services. I see a lot of Fitbits and Jawbones out there, so. Okay, so what? Well, the first so what is just the ultimate, as long as we have the judgment embedded in Title VI and have the classification of cable services, we're going to have a limited scope of the internet net neutrality rules, and the ability to engage in these reallocations of service capacity, bandwidth, if you like. And as long as the cable services model embeds or permits a certain degree of vertical integration, you are going to create that possibility for regulatory arbitrage or business model arbitrage, whichever you prefer to call it. And so I say, as long as you're going to not start at the beginning, although I think we should, my pessimism is not the same as Mark's about starting over. But even if you're not going to start over, you have to have the inevitability of competition analysis. And it's inevitable because you've got these two different systems and the business ability to arbitrage between the two systems. And the second reason, since I am a lawyer, is that as long as the DC Circuit is right, that you can't do in net neutrality full common carriage, Verizon also makes it so as a doctrinal matter. So you're inevitably going to have a competition analysis of some sort in net neutrality itself, and that makes sense given that once you consider the analysis has to be across this boundary of the internet, the specialized service boundaries of the internet, the specialized services, and the cable services, the only way to deal with that boundary is through competition analysis. It makes sense to have a competition analysis in the net neutrality rules. So I think that's all being driven by these regulatory classifications, and that's my piece.
Thank you, Jim. Our next panelist is Gus Hurwitz, who is a professor at the University of Nebraska College of Law. He'll be talking about some of the classification issues relating to over-the-top video.
Let's see. Okay, so I'm going to be focusing on the MVPD side of the question here. What is video from Title VI's perspective, from the Communications Act's perspective? After I speak, Shyam is going to speak, and he's going to look at the Copyright Act side. We've been talking about the open internet, net neutrality part of this question. Classification on the video side has a long and really, I think, underappreciated and very complex and convoluted history, both legally, technically, and also politically. And the political dimension we really don't want to forget about here. So this is just a little bit of background as a reminder. The 1976 Copyright Act was delayed for 10 years. They started talking about it actually about it in the 50s, but really in the 60s. It was held up for a decade while Congress was trying to figure out what do we do about video. And then there were a couple of important cases, Fortnightly and Teleprompter in the 70s, that the Supreme Court said, this is what we're going to do. And Congress suddenly said, okay, well, we need to act now. The 1984 Cable Act was similarly the result of a lot of compromise, several years of negotiation between Congress, various stakeholders. Going back and reading the legislative history for the 1984 Cable Act, I suggest everyone do it. It's fascinating. Okay, fine, laugh at that. But it's amazing. Congress was talking about cable systems using their bandwidth not just to deliver video, but to deliver interactive services, to send computer software to all of their customers, to do news, real-time news and information, online banking. And they were talking about whether or not this would be a cable service or whether or not this would be something else. In the legislative history, the conference reports, the 1984 Cable Act. Fascinating to go back and read. So that's a bit of the setting that I'm going to be talking about and that Shyam's going to be talking about, because in the video context, the statutes make a lot of effort to try and figure out what is video. And we are really tied to a lot of legacy definitions. So I'm going to talk us through some of these legacy definitions. So the basic question is over-the-top video cable. From the Copyright Act perspective, this is a question that comes from Section 111 of the Copyright Act. This creates a compulsory license for cable systems to redistribute, make secondary transmissions of video content. From the Cable Act perspective, Title VI, if over-the-top video is a cable system or an MVPD, I'll get into what that means in a moment. Then Title VI kicks in, and a whole bevy of regulatory requirements start to kick in. Retransmission consent. Does must carry apply? Program access, carriage access rules, other rules. Importantly, an important distinction to understand before Shyam and I get into the back and forth here is the Copyright Act applies to the program being sent. The Cable Act applies to the signal that is carrying that program. Now, this should possibly give you nightmares. Think the distinction between telecommunications and information service. We'll look at a bit of the statutory definitions, and I'll end probably with a couple of comments about this distinction as well. So why do we care? Over the summer, the Supreme Court decided the Aereo case, and it had this language saying that over-the-top video, what Aereo was doing was cable-like. For all practical purposes, Aereo is a traditional cable system. The court seemed to maybe be weighing in on this question, though I think the language was phrased deliberately to be vague and not take a strong position that would bind any of the relevant agencies. The FCC has been struggling with whether or not over-the-top video is subject to Title VI rules. And as we have learned over the last 3 or 4 days, within not up at the 8th floor of the FCC, but the lower floors deep in the bowels of the FCC, the agency might be working on an NPRM that addresses this. This is in response to a program access petition by Sky Angel filed several years ago in 2010, which the FCC has so far done nothing on. Sky Angel filed an update in that proceeding over the summer saying, hey, guys, just so you know, we're shutting down. We've got money. We could afford to do this, but because you've been dragging your heels, we can't keep waiting. We're just canning this business. The Copyright Office has struggled. Arguably, they've just decided without going through the struggle with this classification as well over the last actually 20 years at this point. The future of this question. What about Netflix, YouTube, TV Everywhere, Akamai, content delivery networks, Facebook? Facebook has streaming video hosted on it. If we say Aereo is a cable system, does that start us down the path where suddenly Netflix is, where YouTube is? Is Facebook subject to Title VI under the Communications Act? Scary questions. So the language, this is the Cable Act, the Copyright Act language. I'm just going to put it up so that we have it for comparison. A cable system, a facility located in a state that receives signals transmitted by broadcast stations and redistributes them via wires, cable, microwave, or other communications channels to subscribing, to paying members of the public. So, Copyright Act, you've got broadcasters, you've got a cable system that receives these signals, retransmits them over some infrastructure to people who are paying to receive them. This is the Communications Act definition. It's really long. The bottom half of this is all exceptions. This is the term cable system means a facility. I'm not going to read this all. Why? Because it does not include a facility that serves subscribers without using any public rights of way. So over-the-top delivery does not use public rights of way, at least in the sense that the Aereo, Netflix, they don't own the infrastructure. They're not leasing the public rights of way. So the cable system definition doesn't even apply probably to any over-the-top systems, unless this is a vertically integrated offering. But we're not out of the woods here because there's a second definition that the Title VI uses, multi-channel video programming distributor, frequently abbreviated MVPD. Quick story, when I was at the Department of Justice, I had a colleague who during one case couldn't get this acronym straight. He kept saying MPVD the entire investigation. So at some point we just gave up and said, okay, for you, we'll call it an MPVD. MVPD, multi-channel video programming distributor, is someone, a company, a person, an entity who makes available for purchase by subscribers, customers, multiple channels of video programming. So if I'm making available over the internet multiple channels of video programming, I'm an MVPD. Seems pretty straightforward. Well, nothing is straightforward with communications law. These terms, cable channel or channel, they're defined with the same language. They're defined terms, and video programming a defined term. A channel means a portion of the electromagnetic frequency spectrum, which is used in a cable system, so it's circular. Think to telecommunications and telecommunications service. We've got circularity, which is used to deliver a television channel. That's defined separately by commission regulation. Note, this is tied to the use of electromagnetic frequency spectrum. Okay, the term video programming means programming provided by or generally considered comparable to programming provided by a television broadcast station. So in an on-demand world, is that comparable to the programming you get from a television broadcast station? Television broadcast stations are usually ad-supported. Does video programming need to be ad-supported? Does it need to be in a linear stream? Does it need to be a 24-hour feed? Does it need to be scheduled by a third party? Important questions that we're going to need to grapple with, that the FCC is starting to grapple with. So who decides for both the copyright question and the cable Title VI question? It's the agencies. They generally get broad deference here. There's an open question whether or not the Register of Copyrights in the Copyright Office would be entitled to Chevron deference. In the one relevant case here, the Ivy case from a couple of years ago, the Sixth Circuit declined to address that. They said, well, if we were to give Chevron deference to the Copyright Office, we happen to agree with them, so we're going to go through the analysis on our own. So it's unclear whether or not the Copyright Office would get Chevron deference here. What have they said? The FCC has this open proceeding with Sky Angel. It hasn't said anything. The big questions, the importance of channel in the MVPD definition, the importance of video programming. What about the Copyright Office? Big red stamp here. If I had audio effects, there'd be a thud. Shyam's going to talk about this. He'll talk about the copyright side of things. He and I might disagree, so we might get into some really big fights. We could disagree, in which case this could be a boring panel. On the MVPD side of things, so I've already keyed these up, but I think these are the issues that the FCC is probably going to be struggling with in the hypothetical NPRM that may or may not be in the works. What is linear? What is a linear channel? And is it relevant to the future? So if we tie MVPDs, if we tie over-the-top video to linear programming, this idea of a scheduled 24-hour programming stream that you can tune into at any time midway through a program, that seems like it's the past. It's not the future. It's not the direction. It's not what we think of when we think over-the-top. Over-the-top, we think, I can tune in and start the program when I want to, on demand. What about alternative programming models, a video jockey model? So instead of binging on 24 hours of Buffy the Vampire Slayer seasons 1 through 7 back-to-back on Netflix, you go to your video jockey channel on Netflix, and it gives you a mix of programming, possibly bringing in local news, nationwide news, news and information channels. This brings us to the second question. What's the role of localism? This is something that's really lacking in the over-the-top video ecosystem. One of the key focuses for the FCC has historically been local content, protecting local programmers, local broadcasters, making sure that you can get local news and information, whether emergency broadcasting, public educational, and government programming. None of that really exists online, except to the extent, and I'm in the early stages of a survey project on this to see what's out there, what local broadcasters are doing. Sometimes you can get local news broadcasts, typically in a podcast or segment-by-segment format. You can't tune into your local 6 o'clock news online. I haven't found any local broadcasters who do that yet. This brings us to an important question that was central to the Aereo discussion. What is the role of geographic restrictions in over-the-top broadcasting? So Aereo implemented geographic restrictions to make their system appear and operate like a cable system. Much of the must-carry regime is tied to geographic restrictions. If I need to carry a local broadcaster in Lincoln, or if I'm a cable system in Lincoln, I need to carry any. This is Lincoln, Nebraska, by the way. I'm from Nebraska. If I'm a cable system in Lincoln, Nebraska, I need to carry all of the must-carry channels that are closest to my head end in Lincoln, Nebraska. Well, if I'm a nationwide, if I'm an over-the-top system, I don't have a primary head end. So it's not clear how the must-carry provisions would actually play out and be implemented. Last question, does the channel definition even allow for digital? Does it allow for packetized communication? It's tied to this idea of electromagnetic spectrum, to what the FCC has historically defined in 6 megahertz frequency blocks. When you're talking about IP, you could maybe argue that all packets are distributed over a electromagnetic frequency spectrum in some way, but for those real TCP nerds here, you might be familiar with the April Fool's RFCs that talk about IP via carrier pigeon, IP via smoke signal. You don't need to deliver internet protocol data over electromagnetic spectrums. Important to note here, AT&T's UVerse is a switched digital video system. Comcast is working to develop a IP-based, possibly switched digital video system. Is it possible to differentiate those from Netflix, from over-the-top? Okay, so just to finish here, fortunately, John said since we only have 3 panelists that we could go 15 minutes instead of 10 minutes. We've got 2 agencies with 2 statutes. They're very messy, very confusing. The statutory language, probably the Copyright Office and the FCC could come to a disagreement. The Copyright Office, for instance, could say over-the-top is not a cable system, but over-the-top, the FCC could say is an MVPD. Both are probably within agencies' discretion to define. The hardest questions here, I really think, are about the localism and scope questions, scope of delivery, and the role of local broadcasting, and these traditional things that the FCC has really fought to preserve. If you go back and look at the debates, the entire history of broadcast television was VHF versus UHF and regulating cable in order to prevent cable from undermining the FCC's efforts to promote UHF. Why was UHF important? That was the avenue for local programming. Is the FCC willing to, has the FCC moved away from the local push, and is it now today willing to say, no, video is a nationwide market, a nationwide service? So with that, I'll hand things back to John to hand them to Shyam.
Thanks, Gus. And our final panelist today is Shawn Bal Ganesh, professor at the University of Pennsylvania Law School.
All right, let me begin by thanking Christopher and the organizers for having me. I should also start by saying I'm a little bit of an interloper here because I am by no means a telecommunications person. My expertise is in copyright law, and some of my recent work has been trying to understand the mess coming out of the Aereo decision and the potential overlay of the Section 111 regime and retransmission consent, and where exactly that's headed, where it's coming from, and the overlay over and above that complexity of what Aereo itself has been trying to do in terms of navigating the classification debate. So what I thought I would do in the next 10 or so minutes is talk a little bit about Title 17, the Copyright Act, and its role in classifying cable or classifying these video services, the extent to which we may legitimately or not rely on Title 17 as a classification statute, and look at that through Aereo's strategy and the problems and the problematics of Aereo's strategy in trying to use Title 17 as a classification device. Okay, so a little bit about the Title 17 basic structure architecturally before I get into the Aereo decision itself. Structurally, Title 17, the Copyright Act, has 2 different sets of provisions. One consists of basically very open-ended, neutral, general provisions that define the scope of exclusive rights that copyright owners are to get. So these are the rights of reproduction, the rights of distribution. And the second part of the Act, coming after Section 111 onwards, is basically the regulatory setup, which are carve-outs through negotiated settlements, detailed compulsory licenses, and exclusion and inclusion definitions in order to enter into these regulatory areas. Now, for the purposes of the Aereo case, both of these begin to apply, and this becomes the fundamental problem with Aereo trying to navigate Title 17. As it's set up to go into the Supreme Court and through the litigation in the Southern District of New York and the Second Circuit, the principal question that Aereo encounters is whether its service is a public performance under Section 106(4) of the Copyright Act, right? So in the definitional part of the Copyright Act, you have a very technologically neutral and open-ended definition of what a public performance is, and it's all garnered around trying to adopt a open-ended exclusive right. Now, if you look at the legislative history, of which there's a lot in the copyright context, behind 106(4), you see that Congress was really trying to widen the scope of 106(4) and the definition of a public performance as wide as possible, because they were reacting to, as Gus mentioned, the teleprompter and fortnightly cases, which had just decided that CATV was not a performance, and Congress was not going to have any of it. They wanted to bring in CATV into the domain of a public performance. So they couch it in technologically neutral terms. In fact, the legislative history reveals, as was shown in some of the amicus briefs filed in the Supreme Court, that Congress actually had predicted the coming to age of video on demand in the 1964 reports and wanted its definition of public performance to cover that as well. Simultaneously, however, in 1976, Congress also creates Section 111, which is this compulsory licensing regime for cable systems. And the idea here is that in 1976, cable television is seen as an infant industry, such that a full-blown property right, a la 106(4), would result in broadcasters effectively shutting out cable television. And so cable TV needs this kind of a subsidy. That's the whole idea behind Section 111. But Section 111, being in the nature of a negotiated settlement, is not technologically neutral. It's technology specific. It has a very granular definition, as Gus pointed out and put up in Section 111F3, of what a cable system is, what kind of facilities it needs to have, et cetera, et cetera. Okay, so we get to the Aereo decision of the Supreme Court, which is a mess in so many different ways, but I'm going to focus on one particular dimension of the mess, which is the Supreme Court is addressing, and it's very important to understand this framing, the Supreme Court is addressing one fundamental question. Was the Aereo service a public performance? Okay? The court is not addressing the applicability of Section 111. The court is not talking about the granular definition of Section 111. And in deciding it, Justice Breyer's majority opinion divides up the discussion into two parts, whether Aereo actually performed the work and whether the performance was itself public. Now, to answer the first one, whether it was a performance, the court looks at the legislative history behind this clause called the Transmit Clause in 106(4), and addresses the reality that Congress adopted a really broad and open-ended definition in order to capture technologies that not just were cable television at the time, but that were cable-like, because Congress was trying to predict the future technological improvements that would come from the next generation of what it saw in 1974. So it concludes in language that creates this problem, which I'll talk about in a minute, that Aereo's activities were substantially similar or practically amounted to cable, traditional cable, and that Aereo was therefore performing under the Transmit Clause. I won't deal with the second question, which Aereo talks about, namely whether it was a public performance, which really confuses the opinion beyond belief. Breyer talks about something called a pre-existing relationship, which I'm not going to go into. But the real question is, in making this claim that Justice Breyer does, that Aereo was akin to or substantially similar to a cable service, should the Aereo Supreme Court opinion be considered a classification opinion at all, in any way or form? And my argument is absolutely not. The court was not engaging in a classification exercise. It was merely discerning congressional intent behind the Transmit Clause, a technologically neutral provision, in order to try and understand how expansively it needs to be read. In fact, there's even language, and that quote that I have up there is from the Breyer opinion, where I think Breyer suggests that 111 is a self-contained system that he's not dealing with. He says it creates a complex, highly detailed, compulsory licensing scheme that sets out the conditions, and nowhere is there a discussion of those conditions. So Aereo, the Supreme Court case, on its face, is not a classificatory decision. Well, Aereo's reading of Aereo, however, is very different. Aereo claims that the Supreme Court decision is in fact one that engages in classification, that the court's decision classifies Aereo insofar as it claims that it's substantially similar or practically amounting to a cable service as rendering it eligible for the compulsory license under Section 111. And Aereo makes this argument in two different contexts. One, to the Copyright Office to say, let us into the compulsory licensing regime now so that we can pay royalties and get out of 106.4 liability. Two, in the context of an emergency injunction in the Southern District of New York, pending the final determination by the Copyright Office. And in its briefs, what Aereo does is fairly interesting. It starts taking out the language from the opinion to say that, look, what Justice Breyer, the intent behind Breyer and Sotomayor's references to practical equivalence was in order to have us classified as a 111 cable system. And it makes a couple of extra arguments, which seem to have a little bit more grounding than the actual reading of the justice's questions during oral argument, namely that if we are to be considered a cable system for the purposes of liability, well, then shouldn't we be entitled to the benefit side of what it is to be a cable system as well? There's an extensive amount of reliance on this exchange between Plaintiff's counsel and Justice Sotomayor, where Justice Sotomayor tries to understand what exactly a cable system is and says, aren't you effectively a cable system? And in their brief, Aereo cites this about 5 times before the Copyright Office saying, Justice Sotomayor said, we are a cable system. We are a cable system. And additionally, Aereo argues that the one precedent which the Copyright Office has used extensively to determine who goes into 111 is effectively overruled, which is the IVI case of the Second Circuit, which had held that internet retransmissions are not covered under Section 111, and especially in a situation in which the internet transmitter or the internet retransmitter does not restrict its services geographically. Aereo says in both respects now, we can get out of the IVI decision. One, we are offering a geographically bounded service. And two, we have the Supreme Court case that now says internet retransmissions might indeed be covered by Title 17 and potentially 111. So Aereo makes this filing before the Copyright Office. The Copyright Office doesn't want to have any of it. The Copyright Office says you are not classified as a cable system using the Aereo decision. And the Copyright Office makes a couple of quick points which rely on their past practice, which is we rely on the WEPIX case or the IVI case, the Copyright Office says. Internet retransmissions are not covered under 111. You have not told us otherwise. We don't read Aereo, the Supreme Court decision, to say anything otherwise. Secondly, there's a requirement coming out of the IVI, and the Copyright Office quotes this and sort of emphasizes it, saying, in order to come under 111, we have a requirement that you are regulated as a cable system by the FCC. And therefore, you don't meet both these requirements, you are not eligible for 111. However, the Copyright Office says provisionally we'll accept your money until there's a judicial determination of this classification. So now the big question is, should the copyright law be a legitimate basis for classifying Aereo as a cable system or not? Should we have a harmonized regime between Section 111 and the Communications Act to figure out whether Aereo is in fact a cable system? On the first of those questions, my answer is that I think we should stay away from the Copyright Act as much as possible and from the Copyright Office in understanding the classification. For one, I think the Copyright Act, a large part of it, especially the preliminary part, was designed to be technologically neutral. And if you look at what the Copyright Act was trying to do, it was taking the 1909 Act, giving it a little bit more meat, but in essence, keeping it technologically neutral. The Aereo decision is unquestionably in that vein. To use the application of the general language to specific technology for classification purposes in order to determine entry or exit from a regulatory regime, I think is deeply problematic, given what Congress was trying to do with open-ended language, namely predict the future generation of technologies, in the hope that in the copyright context, unlike perhaps other areas, you would not have to update the Act periodically. So if Aereo's argument, for example, is taken to its logical conclusion, anything that qualifies under a public performance, 1064, let's say a satellite retransmission, should now be a cable system in order to allow it to come under the second part of the bargain. But clearly this is not the case, because under Title 17, there's 119, which deals with a compulsory license for satellite retransmissions. And in fact, prior to the 1999 amendment to the Copyright Act, there was this provision which said that no provision of Section 111 or any other law shall be construed to contain any authorization, exemption, or license through which secondary transmissions by satellite carrier for private home viewing contained in a primary transmission by a superstation of a network station may be made without obtaining the consent of the copyright owner. So clearly there's an indication that Congress does not want an overreading of these technology-specific provisions, and very importantly, that they want to drive a wedge between the technologically neutral first part and the technologically specific second part. The last point, and this is where I think Gus and I are likely to disagree, maybe not, and then it'll be boring, as he pointed out, which is that under the current understanding, the cable system definition under 111 and the understanding under the communications regime have two very different definitions. Should they be harmonized? My tentative answer is yes, and I speak from a copyright point of view. And here's why. First, I think the architecture of Title 17 and copyright law more generally does not allow for an independent classification process under the copyright system as a whole. The Copyright Act was just not designed to be regulatory, other than the overlay of 4 or 5 sections, which come in much later and in some ways have very little influence on the actual structuring of the original content of the Copyright Act. The extensive regulatory overlay of the compulsory licensing regimes, very importantly, is well beyond the regulatory competence of the Copyright Office. And much to their credit, I think the Copyright Office recognizes this. In multiple parts, both in its own rulemaking and embedded into these regulatory provisions, the copyright statute defers to different parts of the Communications Act and to rulemaking by the FCC. It's an explicit recognition that the Copyright Office and copyright law does not want to entertain this question on its own. I also think that the Aereo case and the sort of play back and forth that Aereo is going through indicates that having a perfectly bifurcated regime with 2 separate definitions which don't track each other runs the genuine risk of certain kinds of technologies falling between the cracks and being allowed into one without the other, which was Aereo's original strategy. All right, with that, I'll turn it over to John.
In a few minutes, I'm going to turn this over to questions from the audience, but first I'm going to exercise my moderator's prerogative to ask a couple of questions of the panelists myself. The first one I'm going to direct to Jim, but anyone is free to weigh in. Jim wrote an excellent article that I read over the weekend that was published in the 2011 Duke Law Journal, and it's entitled Supervising Managed Services, and I recommend it to everyone even above the legislative history of the Cable Act of 1984. Yeah. But it raises some really interesting issues, which is the as video services begin to coalesce around the IP platform, you begin to see interesting issues about the interplay between policy issues concerning those video services, specialized managed video services on the one hand, and over-the-top video services on the other hand. In fact, in some contexts, it may be even hard to distinguish between over-the-top and specialized services. But these issues arise, this specter of regulation arises only once an MVPD, a facilities-based MVPD, has decided to make the transition from old-style QAM technology to 21st century IP technology. And my question for Jim is whether the specter of additional regulation, once you make that transition, may have the perverse consequence of creating disincentives for making that transition in the first place, and if so, how policymakers can deal with that while maintaining net neutrality norms.
Ooh, the second piece threw me a little bit. The first piece, I think, the answer is yes, I think so. I mean, it'll be interesting to me, and it's interesting in the way this ecosystem is all related. So, if incentive auctions were to take away a lot of not terribly valuable broadcast spectrum, not sure any of it's terribly valuable qua broadcast spectrum, then the ability to the rights you get from being a cable system under an old technology may not be meaningful anymore. But I think it's related to this classification decision. What rights do you get for being in that particular space? Now, one of the rights you get right now is to not be subject to net neutrality or to common carrier rules, right? Now, under Verizon, maybe common carrier rules aren't possible anyway under net neutrality. But I think the general point is right, that the technological differentiation or the technological transition is being confronted by the or being managed by the regulatory system. What does it mean for net neutrality? I'm not sure
Well, so let me put this a different way. So remember back to the Netflix Comcast controversy of a couple years ago, where Comcast had a new Xbox-related Xfinity service in which video on demand was transmitted over an IP platform.
Right.
En route to consumers, and the packets used were not counted against the subscriber's data cap. And Netflix claimed that was a violation, I believe, of the merger commitments, but more generally of net neutrality norms. Now, that sort of complaint couldn't have arisen in the first place unless Comcast had made a transition from QAM delivery of video services to IP-based delivery of video services, which begin to look more like the kind of internet services to which net neutrality rules apply. Now, you make the point that to preserve net neutrality principles, there needs to be some sort of oversight of specialized services, including the Comcast service at issue there. My question is, how do you balance that desire against any concern, real or perceived, that imposing new oversight of these video services under the aegis of net neutrality will discourage ISPs from making the transition from an old technological model to a new one?
I gotcha. Well, actually, I think that exactly what you've identified is one of the reasons why this category of specialized or managed services, that both, I think the terms mean the same thing, appears, right? Because there's a realization that when the technological transition happens, that if you injected it into the open internet rules or the net neutrality rules, you might well stop them from changing video on demand to the new technology or whatever new fancy service that we would want. So I'm agnostic, right? So I don't think. I think it's inevitable that if you want to have net neutrality rules on the internet side, then you need to supervise the specialized services in order to address the competition issues that you believe happen between the internet side of the network and the cable services side of the network. You just have to do it because it's the same competition law problem. And so my basic perspective is, it's competition across all three boundaries. And the only way to make that work, the only way to eliminate some of this, dancing out ahead of a pin, we've got this technological transition problem, so we need to move to this third category of specialized services where we're going to sort of look at it, is to just admit that what we need to do in the internet pipe is to use a competition way of thinking about things instead of a non-discrimination way of thinking about things. And that's how you get out of this conundrum.
Okay. Any follow-up? If not, I have a question for Gus and Shyam.
Bring it on.
Okay. So Gus and Shyam, and Gus, you in particular, I think identified a lot of the classification challenges that we're seeing. For example, the reported Media Bureau initiative that you talked about would confer certain rights and obligations as an MVPD on over-the-top services that come in linear form, as opposed to nonlinear form. Presumably the reason for that is because the definition of video programming in the Communications Act, which is tied to the way television broadcast stations operated in the 80s. And one thing that I think should concern everyone is that these sort of legacy definitions contained in the statute will cause the FCC to write rules that artificially favor one business model over another, and that's a problem. I'm going to ask whether we can shift the conversation from the merely descriptive to the normative, to ask you what you would do if you had influence over Congress and what you think an efficient solution to these these statutory anomalies might be, so that we don't warp the efficient evolution of video services over a converged IP platform.
So I think that the key is to recognize the converged nature of the platform. And in this sense, I think the Cable Act needs to, and the Communications Act more generally, needs to move in some ways closer to the direction of the Copyright Act in terms of being technology neutral. It's amazing to read the Cable Act, how much technology specificity is just embedded throughout. Simple example, that's very relevant to this potential NPRM. Section 614, the cable must carry rules. They apply to cable systems. They do not apply to MVPDs. There are separate rules for satellite. One of the we saw the definition of channel is tied to specific the electromagnetic frequency, and we see this same definition in a radio broadcast channel, incidentally, in Title III. So I think we need to move away from this distinction between the technology of transmission and the content being transmitted over that technology. It's several people have said this at this point. I expect someone said it today. We're now in an era where telecommunications is an information service. Telecommunications can be provisioned over the top. The entire infrastructure of the Communications Act is based on a distinction between the communications medium and what is being communicated over it. One particular legislative change or proposal, project, whatever you want to call it, that I'm personally intrigued by, and I'm exploring this constantly in the back recesses of my mind right now, would be to tie the incentive auction together with, now this is too late since the incentive auction, assuming it happens, it's that ship has sailed, but to tie it together with a lot of these MVPD issues, and to try and create an incentive for local broadcasters to give up their spectrum in exchange for going online, in exchange for some carriage guarantees so that they would want to go online. Because otherwise they're going to hold on to this spectrum that is worthless, as my brilliant colleague to the right said, as broadcast. But it's hugely valuable for other purposes.
Shawn?
I just wanted to weigh in on that last point, sorry, not the second to last point on what would be an ideal recommendation to Congress. Right. One of the intriguing things, just again speaking as sort of an inside outsider, comparing the copyright regime with the Communications Act regime, is in the context of of telecommunications law, there's clearly a defined agency who Congress is speaking to in drafting the statute. And despite that, there's a level of technological specificity in the drafting that I can't quite get at. So for example, in the copyright context, the reason you have technology neutral language is because there's very little reliance that can be placed on the Copyright Office for an authoritative interpretation that would then be binding on courts. Their primary audience is in some ways the courts themselves. Whereas in the Communications Act, you clearly have the FCC that is going to intermediate. So I would endorse what Gus just said, namely that you go with a sort of open-ended copyright-like regime with the understanding that the FCC is going to give it technological specificity contextually.
Okay, thanks very much. I think I'll open the floor up for questions from the audience now. Yeah. And if you could please identify yourself before
Hi, I'm
asking.
Lynn Stanton, a reporter with TR Daily. And I'm wondering if someone can mitigate my confusion over the insistence that this spectrum-related definition of cable channel or channel must be the one being used in MVPD, because to me it renders that provision completely nonsensical. Not only would it exclude satellite providers who may use spectrum, but they don't use spectrum that is used in a cable system, but it would also exclude cable providers themselves because they do not offer for purchase the piece of spectrum that they're using to deliver their service, which is what the thing says, that they offer for purchase the channels. So and has that been litigated at all in terms of perhaps whether or not satellite companies are in fact MVPDs? So that's my question.
So probably I'm the one who should answer this, and I think my answer is yes. It's confusing. I don't know that's been litigated, and it's actually fascinating, again, the 1984 legislative history, and not even the legislative history, the draft 1982 and 1983 acts had very different definitions. There was a definition for broadcast telecommunications in the 82 and 83 drafts, which would render a lot of our current discussions about classification not necessarily moot, but very differently. I don't know that anyone has litigated. I've done some searching for this, but I haven't done in-depth searching, so this isn't definite. But I don't know that that definition has been litigated or its relevance has been litigated. The FCC has, I think, treated it broadly, so it hasn't been an issue to be litigated.
Additional questions?
Can I ask a question?
Yeah.
So, well, actually, I have 1.5 questions. The half question is just, it's for Shyam. The half question is, yeah, but the definition in Title 17 is different, and it doesn't point at the FCC, right? Mm-hmm. So I don't disagree with you as a normative matter, but it doesn't seem to me that I can get there under my reading of the statute, since it's different language. But more sort of normatively, I mean, even bigger than the normative question John asked is, you know, the compulsory license was designed, if we can say anything other than it was a public choice disaster, to deal with high transaction costs due to more or less bilateral negotiations, and we don't want holdups, et cetera, et cetera. But in the online world, none of that matters anymore once we have OTT. So why don't we just opt for whatever definition makes the fewest possible entities cable systems under Section 111?
Well, okay, so on the first one, I agree with you completely. That's precisely my point. As a descriptive matter, we're not getting there normatively. We should.
Okay, sorry.
On the second one, why don't we just adopt a most expansive? I mean, ideally, the answer has to be yes, right? Because if you look at the particular historical contingency which motivated that public choice trade-off under 111 and all of them, I don't think they exist to this day, right? So the kind of subsidies that you wanted to give a particular infant industry in order to enhance its viability, I don't think exists for these new incoming technologies. The question is, I mean, this has come up in the context of the extent to which, for example, music radio, internet radio needs to be regulated under those kinds of compulsory licensing provisions. There is some belief that they play a particular role to the extent that you can identify smaller infant industries within smaller players within larger group players, such that their joint and collective negotiating ability at the table is significantly minimized. So this was an issue that came up with internet radio, the belief that under the 114 regime, the smaller players were not getting the exact trade-off that you would want in an actual negotiation, and therefore you needed to give them some kind of a special royalty rate setting mechanism in order to do that. But in a universe, if you were to posit that the OTTs don't need that in the world of online transmission, I think you don't need a compulsory licensing regime at all. That's a simple question.
Which might say, since the cable the Cable Act is doing things different other than supervising this negotiation, we might say, okay, we're going to have a different, more permissive definition under copyright that doesn't sweep all of these guys in, but sweep them in for other reasons under Title VI if we still believe in Title VI.
And I think very importantly, to the extent that you don't want to tinker around with the property regime that the general neutral part of copyright law deals with, you don't even need these compulsory licensing regimes, right? They just go off the table. In fact, I think that is likely to be the difference when you go to a new copyright law. You're going to have these general provisions. All the trade-offs, which were historically contingent, are going to be reevaluated and have to be.
It's worth noting that the FCC, I don't know about their current position, but the FCC has long argued against the compulsory license. They've argued that it shouldn't exist and we should do away with it. And again, going back to the Copyright Act history, it was written in an era of pre-modern era syndication exclusivity and non-duplication rules that were subsequently 2 or 3 years after the Copyright Act went into force done away with. So another bit of incoherence there. It's also interesting to note the FCC has often come to the conclusion that they could disagree. The Copyright Office and FCC could have different constructions of their statutes or statutes that don't agree. And in fact, the Copyright Office, even though right now they're saying that they have to agree, in the past they have said that they don't need to agree.
Christopher.
So I'd like to try to put a real-world example to flesh out these issues. And I think one of the example that always motivates me in this mind is AT&T's Uverse. As most people know, when Verizon was building fiber, AT&T got another generation out of the DSL pipe, and they got 30 meg. And they wanted to offer video. So the question I asked to Jim is, one of the things they do is, the way you make video work on 30 meg is, when you're not watching it, all 30 meg is internet. When you are watching it, basically half that bandwidth is devoted to one application, video, from one provider, AT&T. How does that fit with the 2010, with the or previous order and the 2014 order? Because you're basically favoring an application from a source. The other thing the other way they do it, they make it work on 30 meg is, unlike cable, which even now is broadcasting 300, 400 channels to my house, even though I'm no longer in Philadelphia, they do something called, Gus referred to as switch digital video. They only give you a stream when you ask for it, video on demand like. And they are basically, it's initiated by a consumer requesting something. So the question would be, on the copyright side, on your side of the house, how is this different from a YouTube channel? How is this different from people? Now, the linear restriction matters because someone else is a third-party programmer, but there's plenty of OTTs out there who are doing the arrangement third-party choices of what the content you're getting. And to bracket all this, by the way, it's not just Uverse. Comcast is talking about moving its entire, and this is, I imagine the entire industry will move to conserve bandwidth, all to switch digital video, so that will become a general problem throughout the industry.
The answer is, you're right, it doesn't fit. But nobody knows how to play by any other rules than the rules we have. So it doesn't fit. But I think, I don't know what this NPRM is going to say or not, but all players in the ecosystem, including AT&T, including the content providers, and including the FCC, for at least a period of time, all had incentives to line up to say, okay, even though we're using IP to deliver the cable service, we're just all gonna live with the fact that we're gonna treat it as a cable service. And that those days are coming to an end, I think.
So just one quick point. In the Aereo decision, right, this is something that Aereo argues. Aereo says we are not a traditional cable service because the initiation of the stream happens from the consumer. There is not a continuous stream of 400 channels. And this takes us out of the realm of what happened with every other cable system. And Breyer says, no, it just doesn't matter for the purposes of the public performance right. So the answer from a pure copyright point of view, it doesn't make a difference one bit at all, whether it's a performance or not and who initiates it. But should it under the 111? Personally, I think as a normative matter, the 111 regime needs to go. The 111 regime is not serving a reasonable purpose after you have retransmission consent. That's come into the picture.
So there's a really interesting discussion in the Aereo decision. The only technical distinction between what Aereo is doing and a cable system that the court points out. They say this is the only distinction is basically switch digital video. So if you read that, that applies directly to what AT&T is doing, to what Comcast is working on doing. And importantly, to add to this discussion, Verizon has said that they expect, Lowell McAdams, the CEO, said a couple of weeks ago that he expects within a couple of years, Verizon will have a 20-channel a la carte-ish over-the-top video offering. I think that AT&T's UVerse service is, I agree, it's indistinguishable. The fact that it's linear is the hook, but I don't think that that's enough. Importantly, neither Fios nor UVerse are formally classified as an MVPD. Verizon has agreed to treat its system as an MVPD, even though it's never been classified that way, so they comply with must carry and retransmission consent and everything. AT&T has tried to split the baby. They have consistently maintained that they are not an MVPD. They have litigated this many times because they don't want to go through the local franchising process. They've instead said, we're just IPTV, IP delivered TV. That said, they have also argued, back when we had the program access rules, they filed a program access complaint to get Cox Sports Network, Cox's sports content. This was adversely decided against them, and it was private, so we don't know what was actually argued. But in order for them to make that argument, they probably would need to concede that they were an MVPD.
Actually, I think my recollection is somewhat different, but the point is the same. I think AT&T contested its status as a cable system because it didn't want to pay cable franchise fees to municipalities, but it invoked rights as an MVPD to get sports programming, for example, from cable systems that were vertically integrated with sports. But your point is well taken, which is that these statutory classifications have significant economic consequences for people, and as the video ecosystem converges around the IP platform, as it should, because that's the efficient and consumer-friendly thing for it to do, it will give rise to a range of really hard legal issues, which are hard not because they should be hard, but only because the underlying statutory provisions were written 30 years ago, before anyone foresaw the widespread use of the broadband internet as a platform for the delivery of video programming. I should also add that AT&T was probably the first large provider to offer IP-based video services in both linear and video on demand format. My understanding is that a lot of cable systems actually use IP-based delivery today for video on demand type services, and that's what gave rise to the dispute with Netflix about whether this technology should be considered an internet technology and thus subject to the merger restrictions and potentially the net neutrality rules, or instead it should be viewed as just a natural evolution of the old QAM-based cable service that everyone agrees shouldn't be subject to anything other than Title VI rules. That sort of issue is going to keep coming up as engineers come up with ingenious and efficient ways to send video to people over IP-based platforms. We lawyers, or you lawyers, are going to have a lot of fun debating whether or not those services are really internet-based services that should be subject to net neutrality rules, or whether they are instead something else which are presumptively not subject to those rules.
Yeah, I agree, and I apologize because I am not. I'm a Bell system guy. I'm not in the habit of distinguishing between cable systems and MVPDs when I talk. So I'll take your correction. That's quite right. The thing that Comcast said is we're provisioning it separately through DOCSIS, right? Are we making a separate channel for it? We're not making a channel as a 6 megahertz channel for it, but we're provisioning it separately over DOCSIS. And to just say that and to have such enormous consequences just doesn't make any sense.
Oh, and it gets even more complicated because I think some of the provisioning, and Christopher's question, it's dynamic. So if the specialized service isn't being used, then that bandwidth can be used for non-specialized services. Well, can you have dynamically provisioned specialized services? Another wrinkle that, yeah, I agree, no, but another wrinkle.
Of course, if Congress ever does get around to amending the law to address these anomalies, it'll create a new generation of anomalies that telecom lawyers can go on to fight about, just as they did in the wake of the '96 Act.
But our kids will be out of college.
Well, they, yeah.
So I just want to quickly note, unless there's a question that's going to jump up right now, another layer of complexity here. We've spoken about how complex a statute can be. The Communications Act is remarkable in how technologically specific it can be, and we also need to remember the FCC rules. So that I've mentioned a couple times the electromagnetic frequency spectrum reference in the definition of channel. Well, it also references as defined by FCC rules. So the FCC has another 30 pages of rules saying the 6 megahertz band. But then also Section 614, the must carry provision, it makes reference to, it says expressly that cable companies, if they are retransmitting the signal, they need to carry the line 21 information. This is information that's embedded in the signal that's not visible to the viewer. So sometimes the statute gets into really, really detailed levels of technical specificity that from a normative position, let's not just do away with Section 111, let's do away with that level of technical specificity baked into a statute that's almost impossible to change.
Well, and it makes you wonder whether Congress should just, there are trade-offs here, because the alternative to specificity is extreme generality, which of course confers enormous discretion on regulatory agencies. So depending on your view of whether regulatory agencies can be trusted to act appropriately, it may well be a good idea to give them very broad powers, much as my agency has. On the other hand,
we can talk about that.
Yeah,
later.
we can talk about that. Different panel. But the Communications Act is noteworthy for having both, Section 201 and 202, which are extremely broad and confer extremely broad authority on the FCC. Versus a lot of the provisions that were added later in the Cable Act and of both 84 and 92, and then in the Telecom Act of 96, which are extremely specific in the way they address particular issues. And the problem with the generality is that it creates fewer checks on a regulatory agency. The problem with extreme specificity is that they become obsolete within 5 or 10 years. All right. Thank you all.
Please join me in thanking the panel. Well, as we know, these problems aren't going to go away. One of the things we talked about, whether if it's dynamically allocated in the spectrum you use makes it not a specialized service. I see Chief Technologist of the FCC, Scott Jordan, here. What he will tell you is virtualization of everything is what we're at, and the direction things are going, and we're going to have virtualized channels. The idea that it wouldn't be done dynamically actually flies in the face to the way most technology is working these days, which goes to show that these problems are going to get harder, not easier. Thank you all for coming. I want to reiterate one more time, we will have an event 2 weeks from today in the morning featuring Michael Katz, former FCC chief economist and the DOJ chief economist for the Antitrust Division, Virginia Tech engineering professor Jeffrey Reed, Boston College Law professor Daniel Lyons, Meredith Atwell-Baker, CTI CEO, and discussant right now is invited is Sally Wentworth of ISOC. That location has not been set yet. It should happen by today, hopefully. If not in the immediate future, please keep an eye on our website, and we'll push out information under the same channels you found it here to make sure you know where that happens. So thank you all for coming.